Contract and its essentials under Indian Contract Act 1872. Contract is an agreement enforceable by law as per Section 2, subsection H. Section 10 says all agreements are contracts if they fulfill certain conditions. The parties should be competent with capacity. Consideration has to remain lawful. Object should be lawful and the consent of the parties has to be free, and the agreement should not be a void agreement under the Act. Agreements enforceable at law under Section 10, they have got starting point as offer. Offer is made by the proposer. It signifies his willingness to do or abstain from doing something to obtain the assent of the promisee to enter into a legal relationship. The offer has to be clear, definite, complete and final. There are rules of communication of proposal. It can be in writing or oral, but it has to be communicated to the offeree for acceptance or rejection. It can be general or specific. Carlyle versus Carbolic Smoke Ball Company is an instance of general offer. An offer lapses under 6 circumstances. It lapses when revoked before acceptance is effected. Death or insanity of proposer before acceptance also lapses an offer. It can also lapse with lapse of time. Failure to fulfill a condition precedent, not accepting in the prescribed mode, or making a counter offer also makes an offer lapse. An acceptance is always made by the offeree to whom the promise is made. It signifies his assent or act of agreeing, but no one can accept without knowledge of the offer, as held in Lalman Shukla versus Gauri Dutt. Acceptance has certain rules, like acceptance can be express or implied. It should correspond with the terms of offer. It has to be communicated within the prescribed time or reasonable time, and it is complete only when it is put in the course of transmission to the offerer. Acceptance, once made, can be revoked, but revocation can be done only before acceptance comes to the knowledge of the proposer or before it reaches him. As for capacity to contract, the Act says the person should be a major, 18 years of age and above. Contracts by minors are void ab initio, as held in Moheri Bibi versus Dharamdas Ghosh. But a minor can be an agent or beneficiary, but his estate continues to be liable for necessities supplied to him, and a minor cannot be adjudged insolvent. Sound mind is required to understand the contract and to form a rational judgment of its impact on one's interest. Therefore, lunatics and drunken state are not suitable for capacity to contract, but a person can contract even when he is occasionally in sound mind. Capacity to contract excludes a set of people as disqualified to be a party to an agreement, like foreign sovereigns, ambassadors, alien enemy unless permitted by Government of India, convicts undergoing imprisonments, and insolvents applied to be adjudged as such. Lawful consideration is the next requirement. Consideration where, at the desire of the promiser, the promisee or any other person does or abstains from doing an act, and such act or abstention is the consideration for the promise. For example, in Chinnaya versus Ramaya, daughter promises to pay annuity to mother's sister, and that was her act as consideration for the promise of mother to transfer property to daughter. Under lawful consideration, there is the principle of privity of contract, which states under a contract, rights could be invoked only by parties to the contract. A stranger to contract cannot sue, but this principle has exceptions like beneficiary under a trust, assignee of insurance policy, agency, where strangers can also file a suit as they stand on a different footing. Adequacy of consideration is quite interesting. Consideration need not be adequate. It can be some value, means any value, but it has to remain lawful. It helps decide whether the consent was free, and in an agreement based on love and affection, consideration is not necessary. Timeline of consideration is quite interesting. It can belong to the past, it can be from the present, or it can be into the future. It is for something done, doing, or to be done, can be pre-existing, as held in Kedarnath Bhattacharjee versus Gauri Muhammad. An important principle of consideration is contracts without consideration are void. But there are exceptions, like where the contract is in writing and is registered, or it is a contract between near relatives due to love and affection, or a promise to pay for past voluntary acts, or a promise to pay time-barred debt. In respect of lawful objects, the object should not be forbidden by law. Just like sale of lottery ticket in Karnataka is forbidden by law. Lawful object insists that the object should not be immoral. A contract to marry a woman after the death of wife from a subsisting marriage. It is required that the object should not be fraudulent. Just like partner of a firm making secret profits and not disclosing the same to others. The objects should not be opposed to public policy. For instance, an insurance agent is prohibited from sharing his commission earned with the insured. Lawful object expects that the object of an agreement is not injurious to the person or property of another. Example, a moneylender charging bonded labor as a penalty for failure to pay exorbitant compound interest becomes unlawful. It is essential that the object should not defeat any provisions of law, be it a marriage brokerage, interference with the administration of justice, trading with enemy or trafficking in public office, or case of bribery or unreasonable dealings with employees or instances of bonded labor. Section 10 requires that an agreement has to be supported by free consent and it should not be subject to coercion. Coercion means committing or threatening to commit acts forbidden by Indian Penal Code by party to the contract or through a third person. For instance, a widow being forced to agree to adoption before removal of her husband's dead body for funeral is an instance of cruel coercion. Absence of undue influence is the requirement of free consent. Undue influence is dominating the will of another to obtain unfair advantage, like an advocate getting an illiterate lady seeking divorce to transfer property in his name, or a doctor getting a massive gift from a patient without knowledge of the family. Undue influence is presumed in respect of relationship of parent and child, doctor and patient, solicitor and client, and religious advisor and disciple, to name a few. An agreement to be enforceable at law needs to be free from inducement to enter into a contract with the intention to deceive, which is also known as fraud. Where assertions are made without belief in its truth, silence is maintained where it is a duty to speak, there is fraud. In DDA versus Skipper Construction, in a complex of 20 flats, the builders booked and sold 40 flats. It is an agreement of fraud. Agreement with the free consent prohibits misrepresentation. Misrepresentation takes the form of willful wrong presentation as an inducement to cause consent, like overstating the mileage of a vehicle on sale, saying that the company pays regular dividend while it is paying it out of past profits is a mild form of misrepresentation which makes an agreement unenforceable at law. Free consent is distorted by mistake. Refers to erroneous belief about the subject matter of agreement. It might pertain to the identity of parties as held in Scythe versus Butt, or it might relate to destruction of subject matter of contract even before the contract is entered into, or it might pertain to the quantity involved in terms of dozens with one party, numbers with the other, or price perceived as Indian national rupees by one party and US dollars by the other. Any consent which is affected by coercion, undue influence, fraud, misrepresentation or mistake is not a free consent. When consent is affected by the first four, coercion, undue influence, fraud and misrepresentation, the contract is voidable at the option of the party who is losing unlawfully, except when he had means of discovering the truth with ordinary diligence. In respect of mistake, contract is valid if it is mistake with one of the parties or it is a mistake of law, but the contract is void when the mistake is of mistake of fact and the mistake is with both the parties. The fifth requirement is the agreement should not be a void agreement. One of the void agreements is an agreement to do impossible acts, such as an agreement to discover treasure by magic or to bring dead man back to life. Any agreement in the form of restraint of legal proceedings is a void agreement, like obstructing right to legal remedies approaching courts falls under this category. Void agreements include objects which are unlawful, like a contract of employment of a supervisor in cultivation of narcotics. Wagering agreements which are in the nature of sheer betting or gambling will not lead to agreements enforceable at law. However, games of skill like crosswords or speculation on regulated stock markets are considered to be not wagering agreements. Void agreements include unmeaning agreements which are vague, ambiguous, and unclear, like a contract to supply 1000 tons of oil being not clear as to is it edible oil or industrial oil. Any agreement in restraint of trade also will fall under void agreements, like an agreement that prohibits a person from continuing his trade or profession in return for a consideration, except when it is based on a sale of goodwill or when it is a contract under a sole selling agent. Any agreement in restraint of marriage is also classified as a void agreement and hence not enforceable at law, except when it pertains to marriage of a minor. To revisit section 25, any agreement without consideration is a void agreement unless it meets with the exceptional requirements of being in writing and registered, or promise to compensate for something done in the past, or it is a promise to pay a debt barred by limitation law. A contract can be discharged in 4 ways: with performance, with impossibility, with agreement, or with breach. As a contractual obligation, it is obligatory on every party to perform or offer to perform their promise unless they are excused legally. The performance or offer to perform needs to meet certain requirements. It has to be unconditional at a proper time and place. To the offeree, it should give an opportunity to ascertain whether the person performing is able and willing to do the whole of promise, and in respect of the promiser, where he has made an offer and the promisee does not accept it, the promiser is not responsible for any non-performance arising because of the act of the promisee. Where a promiser refuses to perform a contract in its entirety, it is the discretion of the promisee either to persist with the contract or put an end to the contract at that stage itself. Unless the agreement specifies that the performance has to be personally done by the promiser, he is entitled to employ a competent person to perform on his behalf. Once a promisee accepts performance from a third person, he is not entitled to complain against it later. In respect of joint promisers, the promisee can invoke joint and several responsibility on the promiser individually or jointly. Each promiser is also entitled to compel other joint promisers to contribute in terms of indemnifying him. In the first variant of performance, the promiser performs without application. Where no time or duration is fixed, he will perform it within a reasonable time, and he will perform on a certain day if specified during the usual hours of business. Where there is no mention of specific place, he will apply to the promisee to appoint a place and he shall perform there. Under the second option, performance will be preceded by a application from the promisee for performance at a proper place and the usual hours of business. The promiser proceeds with performance after such application. Under the third variant of performance, where the promisee prescribes, the performance will be made by the promiser in the prescribed manner and at the prescribed time. Second mode of discharge of a contract is through impossibility. An agreement to do an act impossible in itself is void, and when it becomes impossible subsequently, it becomes void from that point in time. Where a person knowingly promises to do something which is impossible, he must make compensation for any loss incurred by the promisee through his non-performance. Discharge through impossibility can happen in multiple ways. One of them is destruction of subject matter, like an island agreed to be sold vanishes in a tsunami, or a music hall rented out is gutted on the day of concert. Discharge by impossibility can also take the shape of change of circumstances, like earthquake on the day of scheduled film shooting at a studio which was rented for the purpose. Discharge by impossibility happens when the contemplated event doesn't happen, like hotel bookings along rooms on coronation route attract impossibility when the coronation procession is cancelled. Discharge of a contract through impossibility can also happen when the party suffers death or incapacity. Like A and B contract to marry, but before the time fixed for marriage, A goes mad. The contract becomes void for reasons of impossibility. Government intervention can cause impossibility. Just like where there is a contract to supply imported coffee beans and the government bans import just ahead of delivery, the contract is discharged by impossibility. Similar to impossibility from government intervention, intervention of war can also cause discharge of a contract by impossibility. Discharge can also happen under agreement. One of the forms is novation, where a new contract is substituted for an existing contract. It can also take the form of a rescission, where an existing contract is cancelled or resigned with the return of benefits received by each of the party. Or it can take the form of an alteration, where the parties and their mutual rights are altered. In all these three cases, the original contract need not be performed. The fourth way is waiver, where one of the parties forgoes its rights by an agreement, and the last is remission, where a party agrees for a lower amount for settlement. A promisee may remit performance either wholly or in part. It can extend the time or may accept any satisfaction to its liking. The fourth way of discharge of contract is breach. It can take the form of lapse of time and breach. It is refusal or failure to perform one's obligation. When act constitutes an intention to refuse or repudiate, it is called anticipatory breach, where the promisee can resign and sue for damages, or he can wait for the actual breach on the due date. Discharge by breach can also happen by operation of law, like incidents of death, insolvency, unauthorized material alteration in the contract, or merger of inferior rights into superior rights, just like a rental tenant buying the apartment from the landlord.